All right. Good morning, folks. My name is Commissioner Jill Carmi. I'll be hearing the family law docket this morning. Filling in on this docket a little bit last minute, and I did notice that a video was filed in this case. So I want to talk about that just briefly. So let's go ahead and call that case. Do we have Samantha Mills and Rebecca Mills present?
Rebecca's here.
It'd be Samuel Mills.
Thank you. Samuel Mills.
Present.
I have the parties present. Is DSHS represented in this case?
Yes, Casey Looney is here on behalf of the state for the Division of Child Support, Your Honor.
Okay, thank you. Let me jump into my digital file here. I have this on for a review hearing, and it looks like temporary orders to be issued or discussed today. Am I correct in that?
Yes, Your Honor. It's a review of the GAL report to see if any changes need to be made. I think that the current visitation schedule, the parents probably want to have some discussion about that.
Okay. And then let me grab what was handed to me yesterday. Looks like it's a USB drive with video. And I need to ask, is this evidence that the submitting party believes is necessary to enter orders?
Yes, Your Honor.
Okay. And Rebecca Mills, are you the one who filed this?
Yes.
Yeah, I didn't, all I got was the envelope and the thing in it with the case number.
Okay.
So, Your Honor, I don't believe any of the other, I don't know if Father has, but I certainly don't know if those are videos that I've already seen and reviewed and included in my report, or if that is something new and different. That was not shared with myself. I don't know if Mr. Mills received it.
Okay. So yeah, so let's do that first. Mr. Mills, and I will be honest, we can't put these in county computers, so I don't know what's on it yet. So Mr. Mills, have you received a copy of video?
No, I have not.
Ms. Mills, can you just tell me briefly what the relevance, just a brief outline of the relevance of what this video is, so I can decide whether we need to continue this case and make sure all the parties have a chance to see this?
Yes, I had submitted a little declaration kind of describing what had happened in the video. But I think that it's important for you to hear it for yourself. I think it speaks a lot to Samuel Mills' character, his carelessness as a father. In the videos, he is being abusive, and I believe it's considered torture. He was not allowing me to sleep at 10, 11, 12, 1 a.m., maybe even 2 a.m. He was not allowing me to sleep. He was throwing my pillows.
Okay, so let me, I do see the declaration in the file. So Ms. Day, it looks like this is a video from many years ago.
No.
Well, your declaration says 8+ years ago.
No, that's not correct. This video is from, I want to say it was October of just last year. This was 2 months before we separated.
Okay.
So if those are the videos that were shared with me previously during my investigation, then I did see those. I reviewed those. I do and did agree that there was some concerns and issues regarding domestic violence, and I recommended an evaluation for father. I did not find that abuse was to the level of a need to restrict father's contact with the children. By that time in the marriage, the situation between the parties had become quite volatile, and there are different reports from different persons. Those were video recordings that appeared to be taken by mother without consent or knowledge. I don't know if father consented. It did not appear so. And so I took those just at face value. And I considered that in conjunction with the other evidence that I discovered in my investigation to recommend that father complete a domestic violence evaluation and then follow any recommendations in there. I did not find that there was a significant amount or any reason to restrict father's time with the children.
Okay. So Mr. Mills, given the kind of brief discussion of what's on this video, are you aware of the contents of this?
I'm not entirely sure, but everything described in it of me not letting her sleep, she's done that to me more times than I can count. So she's saying that I'm torturing her. She has performed the same behavior towards me when we've gotten in an argument and I've tried to sleep on the couch. She's flicked the lights on, thrown my bedding, shoved me around, hit me, and then called the police to have them remove remove me from the house and they show up and say no crime is committed. And then I sign a piece of paper and they leave.
Okay. So let me ask the parties this. I'm, telling you all, I have not reviewed what's on this USB and I can't review it sitting here on the bench right now. So one of two things, Ms. Mills, you could choose not to introduce this video into evidence to me, and I can certainly take at face value the fact that the GAL has reviewed it and incorporated it into her recommendations. And so we could proceed with discussing the orders today. Or we could do a set over. I will be gone next week, so it'd have to be at least 2 weeks before we could get this back on the docket. So Ms. Mills, let me ask you first. What is your preference?
If this is just for temporary orders, I'm okay with continuing for today. I know that Commissioner Nelson, who is typically on our case, said that I could submit that to him and he could watch it on his personal computer.
Correct.
That was the discussion that we had. So I don't know if you can get that over to him or how that works, but I would like for him to see it eventually.
Mm-hmm. Well, if you're in agreement because it is discussed via the GAL, if you're in agreement to go ahead and discuss the temporary orders without it, certainly nothing would preclude you from bringing that video into evidence if and when this case goes to trial. So are you comfortable proceeding in that manner?
Yes.
Okay. I think I do have your temporary orders. Let me find those. Did both parties have a chance to review Ms. Day's report?
Yes.
Yes, Your Honor.
Okay. And are there any objections to her report?
I have a few, not necessarily to her report, but the things that were in it.
So what I have in front of me, tell me if I should have something else. I have a temporary parenting plan that was submitted by Mr. Mills, and I have a temporary, doesn't look like there's any restraining order requested with it. So I have 2 temporary orders. Should I have anything else?
I do have a no contact order on Samuel Mills.
That's something that's already been signed, though. I'm asking if there's
Yes.
anything that the folks are asking the court to review today.
No.
Yeah, I'm just
No, Your Honor.
checking my stack to see if anything else came in.
Samuel did serve. I was served with papers late last night from Samuel Mills. And I have prepared just a written statement that I can read if you'll allow it in response to that.
Okay, so when you say you were served last night, are you talking about there's one labeled temporary family law order, and then there's a temporary parenting plan. Are those the documents you were served last night?
I don't believe so.
What were you served last night?
I think it was a declaration.
Are you talking about a declaration from Mr. Mills?
It was a declaration from Mr. Mills, and also it was his certification of completion of the parenting class.
Okay. And the one I have is dated June 25th. Is that what you are referring to?
Yes.
Okay. And Ms. Day, did the parties give you a copy of their proposed orders?
No, Your Honor, I have not received any documents from either of the parties in the last 2 weeks.
Okay.
So no temporary orders, no declarations.
I want to say that those temporary orders were filed at the very beginning before Ms. Tina Day was appointed to us. I could be wrong.
Okay, so Mr. Mills, have you submitted any current temporary orders that you're asking the court to sign today?
I do not believe so. I think everything I've submitted has been looked over.
Okay. So let's talk about the GAL report then, and we'll come back to the orders in a minute. Mr. Mills, let's start with you. You've had a chance to review the report. Have you also had a chance to review the recommendations in the report?
Yes, Your Honor.
Okay. As far as the recommendations, are you objecting to the court adopting any of those recommendations for purposes of temporary orders?
For temporary, Yes, I don't think Rebecca should have the kids primarily. I don't think their best needs are with her.
Sorry, I'm having a little trouble hearing you. Can you speak up?
I don't agree with Rebecca remaining the primary parent for the children. I do not believe she has their best interests at hand. I think she is very selfish and self-involved, and I think she really needs a psych evaluation. And I've been compliant with everything I've been doing. I have jumped through all the hoops, and now I just would like that Rebecca had to start doing some things. So I want to see her get a psych evaluation to make sure she's mentally fit. She has lied and manipulated through all her declarations. There is fallacies in every single one. The one I woke up this morning at 1 a.m. for work and had a declaration on my porch. So I barely had time to read that, but it's full of lies as well. And I don't believe that the children should be around that behavior. She is impulsive and self-interested. She has, throughout our entire marriage, she has kept us in peril because of her impulsiveness. She has blown all our money. She's gone through, I think, over 20 cats, maybe 7 or 8 dogs. I think about 4 or 5 rabbits. I think 12 guinea pigs, 6 rats, numerous hundreds of dollars fish tanks. I think like at least 6 large fish tanks. And then she's recycled fish through them. Like she'll buy a whole school of fish for the tank, get bored of them, sell them, and then buy a whole different breed of fish. And she gets these animals, she neglects them, she doesn't care for them. They defecate and urinate all over the house, and she sees no problem with this sort of behavior. And recently, my 5-year-old son told me that they got ducks. And then a couple weeks later, he said, "Oh, we got rid of the ducks. We got a puppy now." And she's just continuing the same behavior. That's not the behavior of someone who's well.
Okay, so you're objective. I've made note that you're objecting to the parts of the report naming her primary. What else are you objecting to, if anything?
I believe just her being the primary. I have not been able to recently. I've been working long hours the past week, so I haven't really been able to reread that report.
And have you completed the domestic violence evaluation?
I have a meeting on the 5th. I have scheduled it, but it had to be several weeks out.
So you have not done the eval?
Not yet. I'm waiting to be seen on the 5th.
So if cash all of a sudden percent, next thing
and I have scheduled to meet with a lawyer on August 23rd. So in regards to anything deciding the custody of the children, I would like that to be pushed back until I can meet with my lawyer.
You are hiring a lawyer?
Yes.
When are you meeting with a lawyer?
August 23rd.
Oh, that's a ways out. Okay. All right. Anything else you want the court to know?
Off the top of my head, I think that covers it.
Okay. Ms. Mills, let's talk about your review of the GAL report.
Please, I'd love to hear from others.
There were a few things in there that I disagree with, not with Tina Day's recommendation. I mean, I kind of disagree with that. There were just a lot of lies in there coming from Samuel and his mother.
Yeah, and so I understand that actually probably every party disagrees with the other party's statement of facts in these types of proceedings. I'm looking specifically at the recommendations portion. So as we're crafting temporary orders, that's my main concern. I certainly will leave for trial the truth of the matters asserted by parties. But as far as the recommendations for visitation and residential time, summer schedules, communication, those sorts of things, are you generally in agreement with the recommendations of that report?
I am in agreement that I should remain the custodial parent. I have been a stay-at-home mom to these boys since they were born.
Okay. What about the visitation time proposed?
The visitation, I have some slight disagreement with. Since the beginning, I have said that I hoped for every other weekend that they go with dad. And she also added in Wednesday nights, which I think is a nice touch. Maybe only doing that on the weeks that they don't see him on the weekend.
Oh, no.
Alternating weeks, but every other weekend for visitation. I think that it is really important for the kids to get to be with both families for weekends. We have missed out on a lot of fun activities with the kids and the kids with us. We love camping. We love taking the boys places, but that can only take place on the weekend. So I hope that I can have equal weekend time.
Anything else you want the court to know? Okay. Ms. Day, I will turn to you at this point. You've heard a little bit of feedback from the two parties, and I'm interested to hear from you.
Thank you, Your Honor. The current visitation schedule right now allows father to have every weekend. I thought that it made appropriate sense now that we were moving forward from kind of emergent orders that father would have first, third, and fourth weekends, giving mother second and fifth if there is a fifth. I think that's appropriate. She has primary care. She is a stay-at-home parent. She has all week with the children, and father is working. I think that makes good sense. It provides appropriate time for the boys to have time with both families. And yes, everybody will have to make adjustments. I mean, I think that's just a reality when parents separate and they have to share their time. The children have to share their time with both parents. I did ask for additional time in the summer and of course shared holidays, etc. But my hope was that it would help to settle the boys into a more normal routine, and it would allow mom to have some weekend time with her new partner and his child to do things that they, as she just described, without restricting or limiting father's time. There's just no simple reason to restrict. Father is asking for, at least initially was asking for joint custody. Mother has always been asking for primary and sought to have father's time restricted completely. I don't think either of those are in the best interest of these children or appropriate based on the history of this family and how things have played out since then. But I do think regular time, consistent time. I think the midweek visit is important because I think 5 days without seeing their dad is detrimental to them, and these are young children who need that frequent contact. And I think that if father's able to be off of work, that would work very well for the boys. If father's not able to be off of work in time to do that, then those are just kind of real life circumstances. So those are my primary things to add. I do ask that the parents continue to communicate via text or use a parenting app to kind of limit the conflict that has gone on. I would ask the court to order that their communication only occur as it pertains to the boys, or if necessary to the divorce as far as, property and things like that. The texting of inappropriate information, name calling, videos, personal intimate encounters that are happening outside of the marriage and the divorce, I just think are really inappropriate and only seek to inflame and create more conflict.
So as far as the recommendations from the GL report, for purposes of orders at this time, I would adopt those as the court's orders for visitation. I think they're well thought out. I think they conform to the evidence in this case that I've reviewed. And again, certainly Ms. Mills and Mr. Mills, this doesn't preclude the parties from addressing this through, formal trial and fact finding, I believe. And do you all have a trial date set? I don't think so.
No, that would be the next step. If father's going to obtain an attorney, he might want to wait for that, but it would probably be a good suggestion to at least get a trial assigned and a settlement conference assigned.
Yeah, I think that is a good idea. And first, with regard to these orders, and Ms. Looney, I'll ask for your input here in just a second. I don't have any orders in front of me that comply with the GAL recommendations. And I do see, as Ms. Mills pointed out, the ones that were submitted to the court for today's hearing were drafted back in February of 2023. Ms. Day, let me ask you, in a situation like this, I know this was Mr. Nelson's docket. Would he typically just prepare his own parenting plan order, or would he ask the parties to submit
he would ask the parties to submit in the family law matters. They would need to submit those orders and everybody would need to see them. So we could maybe set a presentation for 2 weeks. That would give Mr. Mills time to prepare the temporary orders and share them with Ms. Looney and myself to make sure that they're appropriate. And then we can either come back to court if everybody agrees. If everybody doesn't agree, if everybody agrees, we can just submit them for your signature.
I think that's a great plan. Mr. Mills, I will have you as petitioner prepare the new temporary parenting plan order and circulate to the parties. There's also, Ms. Looney, let me turn to you. What is the state's ask in this case?
Thank you, Your Honor. We were waiting for the custody issue to be determined before we address child support. So our request would be that we set this to the 19th of July, which would give us time to get out a proposed child support order and circulate that as well so that we could do everything at the same time.
I think that works great. Ms. Day, will the 19th work for you?
Yes, that works for me. And if Father can prepare those orders and email them, everybody can have a chance to look at them and maybe make some adjustments if necessary.
That's great. Now, Ms. Mills and Mr. Mills would renoting this for July 19 to finalize these temporary orders work for the two of you. Again, it would be on our 9 a.m. docket via Zoom.
Works for me.
I'm not sure. I might have obligation to my union hall that week.
Okay, let's go ahead and set July 19th since you're not sure whether that will work or not. Let's set July 19th at 9 o'clock. Mr. Mills, if you do have a work obligation that comes up and you know about it, a week ahead of time, please reach out to the court and they can work with you on rescheduling, okay? Okay.
May I interject about the parenting plan? I'm sorry, I was just waiting for a good moment, but there wasn't one.
What part do you mean? I did hear from you on your objections.
Well, okay, so the suggestion where I miss the second weekend of every month.
Where she gets second and fifth?
Yes.
Are you objecting to that?
Yeah, I don't see why she needs any weekend. She's home with them all day and her boyfriend's days off are Monday and Tuesday. The weekends really mean.
So here's why the court is going to do that. Where a parent has children Monday through Friday, typically that means that parent is doing a lot of just education and learning with them. The weekends are the fun time. I'm not going to take away a weekend here and there from the parent who's doing the Monday through Friday work.
Rebecca has never.
All right, Mr. Mills, that's going to be my ruling. I understand your objection. Okay. You are welcome to raise this at trial for your permanent orders, but I am not going to budge on that issue with your temporary parenting plan. Okay, so we've got this reset to July 19th at 9 a.m. And Mr. Mills, if that runs into a conflict with your work, please let the court know. Is there anything else we need to do on this case?
I'm sorry, mate. This is related to Tina's Day's suggested parenting plan. So it refers to the holidays. It says that I get the children July 4th and 5th this year. I'm off all weekend and through the 5th. So according to that plan, I would have to take the children back to their mothers for 1 day just to take them back for 2 more.
Okay, well, we won't be, this order wouldn't be signed until at least July 19th. So whatever current plan you two are operating under would be in effect for next week. Okay. Is that your question? It wouldn't be this. It would be however the two of you are working visitation right now.
All right.
Do you have a question about that?
No, Your Honor.
Okay. Okay, and then Mr. Mills, are you aware how to circulate proposed orders to all the parties for review?
Not really, but I can figure it out.
Okay, do you have contact information for Ms. Mills and Ms. Day?
Yes.
Okay, and then Ms. Looney, are you needing copies of those orders also?
Sorry, Your Honor. No, I don't.
Okay.
I just will be sending out the child support order.
Okay, great. Okay, well, it sounds like we've done what we can do on this case today, and we'll see present, and so can you unmute at 9 a.m. And do we have Ms. Vianola present? And if so, can you unmute? Just looking through our system here. I'm not seeing either of those parties present. And I did sort of question if they would appear today, given that they just had a trial set for July 6th. So I'm curious if they thought that that canceled this review date. But Ms. Height, I'll turn it over to you.
You're correct, Your Honor, that we were just in court yesterday to set a trial for July 6th. At that time, it was noted to the court with both parties present that this was going to be reviewed today. So I know that they were aware that it was going to be happening. Excuse me. So that's precisely where we are at this moment.
Yeah, okay. Well, without them present, and this just definitely wasn't the first case called. So, if it was 9:05, I'd probably give them a little bit more time. I don't want to hold up your day because I don't think I have you on any other cases.
I appreciate that, Your Honor. I believe this is my only case on this docket.
So what would be your request for today? I mean, normally if there wasn't a trial next week, we could set this over and give them another chance to appear. But trial scheduled for July 6th. So what would be your request of the court today?
I think realistically, this case is going to go to trial. And I think to let it play out on July 6th is probably the most efficient way to go forward.
Okay. I would agree with that. And I think what I'll do is just note, obviously, that the court did receive and review the GAL report timely. Ms. Height has complied with her obligations under this court's timeline. So I will also find that neither petitioner or respondent are here for me to make any or have any discussions about objections or agreements to the GAL report. So I'll just kind of leave that hanging in the air for trial. And we'll strike today's date and take no action.
All right.
Except to note that your report was timely filed.
Thank you. I appreciate that.
Of course. Anything else you need on this matter?
I believe that covers it, Your Honor. Thank you.
Okay, thank you for your time. Digital file first, I should say. And then is the state of Washington present on this for temporary orders?
I am present, Your Honor, today, but we're not addressing child support.
Okay. Okay, so what I see as the first issue, and I'm going to fully acknowledge that this case has been, as the parties know, going on for a lengthy amount of time. I am sure there is history to this case that even if I read every single document back to 2017, I still would not fully be up to speed on. So just know that correcting me about facts of the case or what the parties are wanting to do today is perfectly acceptable. Jump in if I'm getting something wrong. But the first thing I see, and we'll try and take it step by step, is that they're originally back on May 31st, which was the most recent hearing with Commissioner Nelson, that the Ms. Shoemate was ordered to include Salmon Creek Legacy in an ROI. And the father was going to check that he had access to the child's medical information and that would be reviewed today. It looked like there was a contempt finding on that issue on that date. So let's just start with that specific issue. Ms. Shoemate, have you been able to make progress on that?
Yes, and I have sent it to Kyle.
Okay. And sir, have you received access to the medical records?
Your Honor, the only thing I've ever received from Carissa is a text message with a phone number and an address. That is it. That's the only thing I've received from her.
And what is the phone number and address? Was that to Legacy or what was that a phone number and address for?
It was to Legacy, but there's been no information about an ROI signed or anything.
Okay. So you don't, have you been able to log on and see whether you have access to the child's records?
I do not have access to the child's records because no ROI has been signed.
Okay. So Ms. Shoemate, tell me what's going on with that.
I was told because he is the father, didn't need to do that, but he should be able to just call and they should be able to talk to him.
Who told you that?
Somebody in the medical records.
Okay. So you are aware, I understand you might have taken that directive from someone in medical records. But on May 31st, a judicial officer in this superior court issued a contempt order, finding you in contempt and stating that the contempt could be purged or corrected if you provided names of medical providers and signed a release of information for each. And it sounds like you have not done either of those things, but instead chose to ask medical records if you should do it. Am I wrong in my understanding of what's happening here?
No, I talked to somebody in medical records, told him it was court-ordered that I signed something for him to have medical records, and they said I didn't have to, that because he's the father, he can call.
So I'm just going to ask you a question, do you understand the order that was signed by the judicial officer mandating that you do that? Have you seen that? Do you have it in your possession?
I do not.
Okay. Were you present on May 31st when Commissioner Nelson ordered you to do those things?
Yes.
Okay. So help me understand why your decision was to ask someone in medical records if you needed to do it versus simply doing it and complying with the judicial officer's order.
I was asking how to do the ROI, and I was told not to. I didn't have to because he's the father.
And Your Honor, the issue I run into is every time I call stating I'm the father, I have to prove it. I have to jump through loopholes. I have to get birth certificate. I have to prove who I am. I have to physically drive in to give my ID. I shouldn't have to do that. I should already be on there to have information. That's why the release of information is necessary.
Yeah. I mean, frankly, sir, I have to show my ID when I take my kids to the doctor's office too. I mean, that's not a huge hoop, but here's what I'm going to do on this issue. Ms. Shumate, regardless of whether medical records tells you do or do not have to do this, the fact is there is a Superior Court judicial officer who has signed an order that has a binding and legal effect on you that states you do have to do this. So I'm not asking you to call medical records and ask them whether you need to do this. I'm telling you that you need to sign ROIs listing Kyle's name as someone who can get any and all access to the child's medical information. So I'm not going to find contempt again today because I think that would be your third contempt finding. I'm going to give you a little leeway, but not much. So I'm just wanting to be very clear today that before I let you parties go, we will set a review date just a couple weeks out. If it is not done by then, if you haven't filled out the releases of information, then I will entertain another argument on contempt, which would be your third contempt finding. So I just want to be very clear. Go to the facility, fill out the ROIs with all of the medical providers' names, listing Kyle as the person who can receive and access information. That's all you need to do. You don't need to ask someone if you need to do it. You just need to do it. Okay?
Okay.
Your Honor, I believe we do, in previous hearings, we did ask for also every school record as well. Do you have that document?
I don't. I just have, the only thing I show in the last hearing minutes was that you all discussed obtaining medical ROIs to include Salmon Creek Legacy and any medical providers.
Okay, may I put in a request to do schooling as well, every school she's been to?
Ms. Fellows, what's your understanding of that request? I don't see it in front of me, so I don't necessarily want to pile on, but.
What I can say is that there have been a number of schools that Taylor has gone to, and to be able to track down those records has been very cumbersome. Mom has not exactly been forthcoming about all the schools, and the father's just trying to get all of the records together for her to have. So I would actually add that as well. Yes.
Okay. So what I'm going to do today then is just a bench order. I'm going to reiterate the ruling of Commissioner Nelson regarding the ROIs for medical. And then it sounds like, and sir, you can correct me if I'm wrong, you're just wanting her to provide a list of all the schools and then ROIs for those schools?
Yes, so that I myself can obtain all records that I am seeking myself.
Okay. Okay. I will add that to the bench order, ma'am. Do you understand that you'll need to provide a list of schools attended and ROIs for those schools as well?
Okay.
So because we are adding a little bit of homework to you, let's go 3 weeks out. I'm thinking I was originally going to do 2, but let's do 3. I think that'll put us July 19, if I'm not mistaken, at 9 a.m. Will that work for the parties? That'll be, to be very clear, that'll be a review date to make sure that the ROIs for medical, the list of schools, and ROIs for schools have been completed.
Okay.
Your Honor, I would ask maybe to make it easy.
Yes.
Is mothers should have a list to be able to list off all of the schools and the dates that she signed the ROIs, and a list of the medical providers and the dates that she signed the ROI, and be able to provide that to court on July 19th. That way, in my mind, it would be very clear to all parties on where those ROIs, or what agencies and schools, and what date those ROIs were signed.
Okay. I can absolutely add that to the order. Thank you for the input. I appreciate it. So what I'll do is make a note. Sorry, I'll put that in the bench order. The parties will receive a copy of that bench order from my judicial assistant. And it's going to be very clear, ma'am, what we're wanting. And that on July 19th, I want 2 things to have happened. One is for you to have completed the tasks. And then number 2, try to, with a few days before that hearing at least, so I can actually have it in our court system, please file with the court clerk the proof of the listing of the names of medical providers and schools, and then the dates that you did sign ROIs with each of those agencies, okay, or facilities.
Okay.
Do you anticipate any difficulty in getting that done before July 19?
I know a couple of them are out of town, so it's getting there is the problem.
So we are in summer months. So first I would probably call district offices wherever those schools are located. I know the schools themselves probably won't be open, but the district offices will operate all summer. I'm sure it's something that they're very used to doing via email. So I would just recommend you do some legwork actually calling the districts for those schools. Okay.
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 And anything that she files, that she needs to provide copies to both myself and the father.
And ma'am, do you know how to send copies to Ms. Fellows and Mr. Weiss?
Yes.
Okay. Okay. So that'll take care of the contempt and review issue. I am also showing on this matter that we're here to discuss temporary orders. Is that the party's understanding?
Not quite sure. I know today was about the medical IROIs.
Okay, so I'll tell you, ma'am, have you received, I'm looking to find a date here. Mr. Weiss did submit a temporary family law order and a temporary parenting plan. Oh, these are old ones as well. These were back from January. So are the parties wanting to hold off on temporary orders until our next review date?
Yes.
Yeah, yes, Your Honor.
Yes, Your Honor.
Okay. And so, Mr. Weiss, what I would say is because the last orders I have are January. If there's something that you want the court to review more recent, I would submit new orders. If nothing has changed in your request since January, certainly no need to submit anything new, and you can just let me know that. But again, I know this case has been going on some time. I don't know if the situation has changed since January, so just a heads up for you.
Sounds good.
Okay. And then I know since the state is here, since we're not taking any action on temporary orders, is there any state input at this time?
Yeah, I was having a hard time getting unmuted, but no, we're only here as to child support, Your Honor, so we have no input today.
Okay, thank you. All right, anything else, Ms. Fellows, Ms. Shoemate, Mr. Weiss, that you need on this matter? I show that kind of takes care of what was on my list to do. Please tell me if I've missed something.
No, I think that's about it for today.
Okay. Review. And then we'll see the parties back
report.
on.
Does that sound correct to the parties?
Yes.
It looks like. Oh, go ahead.
I was just saying yes.
Okay. And then it looks like at the last hearing on May 10th, there was an order for hair follicle and mental health testing for father. We can maybe talk about whether that's been done. And then the report, the GAL report review date was set for today. So those are kind of the two things on my list. Is there anything else the parties were thinking we would accomplish today that I haven't mentioned?
No, Your Honor.
No.
Okay. So let's start, while I'm waiting for that report to come in, let's start with an update on hair follicle testing and mental health evaluation. So I'll turn to you, sir, Mr. Hart, and let me know where you're at with that.
I got both of those accomplished.
Okay.
I got the results for the hair follicle test turned in. I haven't gotten the results from the mental health evaluation, but they didn't recommend any counseling or give me any diagnoses.
Okay. And I think the records that were submitted to me first were from Ms. Hart, showing full compliance for the month of May with your obligations, and also fully negative testing. Does that sound right to you, Ms. Hart?
Yes.
Yeah, thank you for submitting that. So I think, sir, I certainly will take your word that you have accomplished those things, but the court will need some sort of evidence similar to what Ms. Hart has submitted.
I'm just waiting for the ROI to sign to turn in so that they can send it over there.
Got
Yes,
it. Okay.
Your Honor, I should let you know, he did send me the results of his hair follicle test. He needs a new ROI for the mental health assessment. So I'll be sending that to him today so he can get those shared as well.
Got it. Okay. And let's see. So on that, I guess we could just do, are you guys set for trial yet?
No.
Is this going to trial?
Well, I'm going way, way back. Give me just a minute here.
That's the first time I've heard of that.
Yeah, I hadn't heard that we would require a trial.
Oh, okay.
Neither one of us want to go to trial.
No.
Okay. So the last, when this came back in front of the court after long history, it looks like back in March when the GAL was appointed, one of the parties had filed an order for adequate cause. The court said, we're not going to address that right now. First, we're going to address contempt, and then they assigned the GAL. So I don't actually see, and you guys can help me out here, if there's still, it seems like out in the ether somewhere, there still is this motion for adequate cause that hasn't been addressed since March. So maybe the folks can fill me in a little bit on what the folks are wanting the court to decide.
Today, when I turned in my medical documents last week, the clerk told me that none of that was going to be happening today. Today was just the GAL report review.
Right.
And so today I'm hoping that after I had a chance to read the entire report from Heather, that I asked the court that adopt her recommendations on that on her report.
So you both have had a chance to review the report, is that correct?
Yes, I've read the whole report.
Well, I guess what I'm trying to get at and is obviously we're going to discuss the GL report. That's why we're here today. But I'm just trying to make sure I understand what the ultimate goal is, because the reason a GAL was assigned is because someone filed a motion for adequate cause that hasn't yet been ruled on. And my assumption is that's because someone wants to change something that was ordered previously. So help me out there a little bit.
Okay, and I'm the one that filed the motion for adequate cause, and this is all kind of confusing to me, as so you know, because me and Mr. Hart were in complete disagreement with both of our proposed parenting plans that we filed at that time when the court appointed the GAL, because we were in complete disagreement. And so she did her report, and the clerk told me that I was probably just going to need to refile a new proposed parenting plan once all this was done. And I think with the GAL's recommendations, all the visitation and everything, it is going to be a process, which I am in agreement with. So I think at this time, the papers that I filed it way back when at the beginning of the year are just kind of, they aren't pertinent right now.
Okay. That helps me out a lot. I appreciate that. So I'll turn to you, Mr. Hart. Have you had a chance, I'm just waiting for that report to come in still, but have you had a chance to review the GAL report and recommendations?
I do. I agree with pretty much all the recommendations except for she recommended a non-professional person for the visitations, for the supervising the visitations, and I don't know anybody. She said she wanted both parents to issue 3 names. The only person that's associated with my ex-wife that I trust at all is her mom, and she lives in Las Vegas. I don't know anybody around here that's willing to do that. My parents aren't willing to be the supervisors for her visitation. And I don't know anybody that's willing to put in that kind of time and responsibility. And that's why I asked that, it'd be under a professional setting. And that's pretty much it. There's a couple of points in the order that, or in the report that are just like not factually correct, but at the end of the day, it's not going to really change anything, because I've never said that I didn't want Catherine to not see her son. I just wanted it to be under supervision and be safe for Eric. And so that's pretty much it.
Okay.
I would like to know when she's going to be, if ever, like at all financially responsible for him. She's not paid any child support. She's never bought him any clothes. She doesn't financially support him in any way, shape, or form. I know that she's not legally bound to by means of like any type of court orders to take away, like driving privileges or anything like that. But it just like, I know that it was part of the original contempt charge that she get caught up on that, and she just never has. And so like, that is kind of a concern. But mostly my biggest concern is that I believe that it needs to be in a place that we can just pay, so I can trust people, because I just don't trust anybody that has anything to do with her except for her mom.
Can I speak to that for a moment?
Yes, absolutely. So, sir, I'm going to turn to Ms. Call here. Go ahead.
Yeah, I can certainly appreciate where Mr. Hart is coming from on that point. My concern around it is my interest, and I believe the best interest of the child is starting to reconnect with his biological mother. Mr. Hart is not invalid in requesting that. The issue becomes resources. Do we have the resources available? I actually agree that Ms. Hart should have to catch up on her child support payment. And I understand where Mr. Hart's coming from in that request. I'm not sure that those resources are available, and to withhold even more visitation due to that lack of resource feels concerning to me. It's a county pay case at this point. We have both parents who are officially unemployed at this moment in time. And so preventing the child from having contact visitation with their mother for that purpose, I was trying to avoid that situation. That's where I'm at with that suggestion.
I'm not suggesting that we like not let her see Eric because of the unpaid child support, because like she's never paid child support, so I'm like completely used to that. I was just bringing that up, but the main thing is the supervised visits, because I just don't trust any of her associates, and I don't know enough people around here that have that kind of time or are willing. don't hang out with any of the same people for the most part that I did when I knew her. So that's pretty much it. But the whole thing about I'm not trying to stop her from seeing Eric because of the lack of child support. I was just wondering if that's ever going to be. I was just bringing it up. It doesn't really matter though.
Yes, it sounds like your primary question, or I guess question probably doesn't really sound like it's an objection, but your primary question about the GAL report surrounds who would do the supervised visitation. Is that?
That's my primary concern about it. Like I have some objections to the facts that she listed down. Like I was misquoted a few times, but that's not going to change the outcome of anything. So it doesn't really matter. Like I don't need to bring that up.
Right. And you probably heard me say to other folks, I'm more concerned with any objections or agreements to the recommendations. I certainly understand there's at least two sides to every story. I get that.
Yeah, I have no objections whatsoever to like the timeline. I think that's all great.
Okay. Well, Ms.
It's
Call,
just the supervised visit thing. Sorry about that. Sorry to keep cutting you off.
and who does the supervised visits? And you're saying you don't know anyone who could do it.
I don't know anybody that is willing to do supervised visits for Catherine, because my parents aren't. They would be the only people that I would know that's willing to do that kind of thing at this point in time. But they're not trying to put up with that stress. They're just not willing to do that. And yeah, I don't trust any of Catherine's associates.
Okay. Well, Ms. Call, I'll turn it over to you. I still don't have that report, but I'm sure it's making its way through the printer system and into the courtroom, but I'll have you go ahead.
Like I know before her, like one of Eric's teachers before had offered to be like to do the supervision. There might have been a school counselor. I can't remember.
Okay.
Like I don't necessarily need her to pay for it. I don't care if it's like expensive or the cheapest place in town. I just need it to be somewhere that somebody that I could trust.
Okay. Thank you, sir, for your input. Okay, Ms. Call, go ahead.
Yeah, I confess. So kiddo actually does live with Mr. Hart's parents. So I do confess that my hope was that would be a situation where we could have that occur. I believe Mr. Hart in saying, and again, I don't expect Mr. Hart to carry a lot of trust for Ms. Hart at this point in time. But I'm trying to think through a quick solution to this. If it really is true that there's absolutely nobody in town who could handle a non-professional supervised visit, then perhaps we do have to ask for a supervised visit. I'm not a professionally supervised visit. I'm not comfortable, mostly for Eric's sake, of putting him in a situation where he needs to now be with somebody he doesn't know at this point in time, or somebody who we have a long history of needing to rebuild trust with and rebuild a relationship with. And so there does need to be supervision. In my opinion, there needs to be supervision of some kind, mostly for Eric's benefit, to help him be as comfortable as possible as he rebuilds this relationship. So if it's really true that there's absolutely no one, if Miss Hart has a solution to this issue and Mr. Hart can agree to somebody around, I think that would be my number one hope, that they could come to an agreement. If that is absolutely impossible and there's just no way forward, I think that we do have to go to a professional supervisor.
Yeah. Ms. Hart, let me turn it over to you. Do you have proposals for folks? And obviously Mr. Hart would need to agree, that could be there for supervised visitation. Otherwise, as you heard, and I don't know any other solutions beyond professionally supervised visitation, which does cost some money.
Well, I just got this report, last night when it was emailed to me, so I haven't had a chance to reach out to anybody yet. I would have to say that I don't associate with a lot of people. So I haven't gotten that far. Right now, I was just kind of focused on getting these phone calls started. I do have my best friend, Melissa Tavares, who would be willing to do the visits. Mr. Hart knows her very well. She's been my best friend since I was 10. She's a legal assistant down in Vancouver, but would be able to make herself available to do the visits.
Mr. Hart, do you know that name?
I do know Melissa. I don't trust her at this point in time.
Okay. That's fine. Here's kind of my thought with this. I think what I'd like to do today, and I'm not trying to cut parties off, please, we'll continue discussions. My thought is, since I don't have the report yet to look at anyway, and it sounds like maybe the parties could use a little additional time to come up with a potential solution for supervised visitation. What if we set this over just 2 weeks? I would certainly note that the GAL report has been filed in a timely manner. And then we'd come back in 2 weeks where maybe we all have a little time to pick our brains about a potential solution. I'll say the catch-all, if we don't, is that it's going to be supervised visitation. And if there isn't money for that, unfortunately, I wish I had a solution to that, but I don't.
Can
Go
I
ahead.
share? I'm just hearing from a fellow GAL some information that I personally didn't have, which is that Parents Place, while their availability is limited, they charge $25 an hour, which is very, very low. And then Beth Fellows actually can do supervised visitation through her company, and she charges $45 an hour. So there are reasonably priced options should we need to go that route.
Okay.
But Your Honor, if you're comfortable giving Ms. Hart immediate digital visitation while we work on this, I'd really like that for both people involved.
Okay. Let's, Mr. Hart, what is your take on it? Well, first, Ms. Hart, Mr. and Mrs. Hart, actually, you both will have to be a part of this. Do you both have the tech capabilities to engage in Zoom or FaceTime visits between Ms. Hart and kiddo?
Yes.
Yes.
And Mr. Hart, is that something you would be comfortable with?
Facilitating that once he gets back home. Yes.
Okay. When could I'd like to do a bench order that does allow that. How would the parties like that to be crafted?
Well, right now, Eric is with my mom in Nevada, and he will be for 3 weeks.
Okay.
He has been asking her to be able to text me, and he wants to video chat with me, but we were just kind of waiting until court today, hoping that it would be a thing that the court would allow. And so I would ask that the court allow the visitation, electronic communication start immediately, like Ms. Call asked for as well.
Mr. Hart has stated that he trusts Ms. Smith, Ms. Hart's mother, so much so that he sent his son to go stay with her for the next 3 weeks. So I don't feel like
after reading the GAL report, I take that statement back, actually. Just to throw that out there. She lied to me several times about certain statements that were proven to be incorrect in the GAL report. But I would just much rather prefer that he be home with his whole entire family before that starts, so he can be with his Grammy Papa. He's only with Grandma Alice, a few times for a few weeks out of the entire year. And I feel like it would just be much better served for him if he was here with everybody else to just unpack all that.
Well, here's what I'm going to do. I am going to issue a bench order that I guess, Mr. Hart, here's what I think about. Obviously, you trust this woman enough to have your child. So I believe I can more likely than not trust her enough to supervise electronic communication with Ms. Hart. Is there no electronic communication occurring?
That's correct.
There hasn't been any type of communication whatsoever.
Yeah. So let's do this. Let's just kind of baby step this in a little bit. Let's say twice a week. I don't think I want to go into texting at this point. I think that can get a little back and forth and maybe difficult for kiddo to receive tone of voice and face and that sort of thing. So let's say starting now, and I'll do a bench order, 2 times a week, up to 30-minute video calls with mom are allowed.
Your Honor, also by using the Our Family Wizard app,
Okay.
I could monitor all of those conversations and see all communication.
Oh.
That's the beauty of that app. So it's not just Miss Hart and Eric communicating, or Miss Hart and her mother communicating about Eric. It's actually, if Miss Hart is required to only communicate with Eric through that app, it's all it may help Mr. Hart feel some security in that all of that is being recorded and kept somewhere.
Okay. And forgive me for not being super knowledgeable about Our Family Wizard. Does that allow video calls, or is it just at texting? Oh, it does.
Yeah. Mm-hmm.
That's great. Okay. Perfect. So let's do that. I will include that the communication will go through Our Family Wizard. And then if the folks want to set this for 2 weeks out to finish our review of the GAL report, my thought is, if Mr. Hart, you are having heartburn about any of the communication that has taken place, we will also address that on our 2-week check-in. So that would be July 12th. I believe, if I got my dates right. Yeah. Will that work?
I'm on the Clark County docket that morning at 9 a.m.
Oh, okay. Would July 19 work?
Yes.
Sort of.
Yeah, I have another case that morning, but I think it may be the same docket. I'm still waiting to find out, but yes. Mhm.
Okay. And Mr. Hart, Mrs. Hart, will that work for you, July 19th? So that'll put us 3 weeks out.
Oh, yeah, that should work.
Okay. Okay. And so I'll just note for today's record, report is timely filed. I just need a chance to review it. I've listened to the parties' discussions about any questions or concerns they have about the report. And then Mr. Hart, I still believe if you can keep working with Ms. Call on the ROI and mental health records and that sort of thing, that will be helpful before July 19th as well.
So does the report, does that get amended once the mental health records come back? Because she says in the report that she recommends certain things that wasn't recommended by the professional. So I'm not sure how that gets fixed in the official report that's going to the court, because she's not a mental health counselor. She made recommendations as if she was, and if she knew the results of what they would be, and that they turned out not to be that way.
I haven't been provided with the results of your mental health assessment, so I didn't have that as I was writing those recommendations.
You did assume in your paperwork.
Well, sir, I'm going to stop you there, sir. What I'm going to say is that the GAL and the court will rely upon mental health professionals for our final recommendations and orders. What you have right now, and often what courts do, is say, hey, like, we're not sure what's going on here. Based on some evidence we have, we think maybe this, but we would like a professional to weigh in. That's what's happened here. So this isn't a situation where Ms. Call is trying to be a mental health provider. This is a situation where she is asking for input to this court and to herself from a mental health provider. So, sir, the steps that you're taking, the report that you're getting, assuming it says what you say it says, perhaps there isn't further treatment to undergo, but we have yet to see that. So that's what we're waiting for.
Okay.
Okay, does that help?
I mean, I guess.
All right. Well, we'll see the folks back here on July 19th, and we'll address all of these issues again based on new information. Okay.
Thank you very much.
All right, Mrs. Hart, Mr. Hart, there was a notice of hearing for a motion for order for deadline extension of a final GAL report. There then also, this was set for review hearing for a GAL report. I also show that we're on for a show cause contempt issue that I believe was brought. Mr. Rooney. So Mr. Rooney, you're the moving party on the contempt request.
Yes, Your Honor.
Okay. I'm gonna just note that. And I think, hold on, let me check my next page. I think that's all. Have I missed something?
One of the reasons I asked for the extension, Your Honor, is that I have yet to receive, at our last hearing, there were assessments ordered, and I haven't received sorry, I haven't received the outcome of those assessments to this point. I'm not sure that they've even all been scheduled yet. So I don't feel comfortable completing the report and making my final recommendations until we have that information.
So Mr. Rooney, have you done a mental health assessment and hair follicle test?
I have not done the mental health assessment yet. I've been running into a timing issue with work. I've been talking with my boss. We got a new hire that is going to be able to cover my shift so that I can schedule for a day off during the week to do the mental assessment. I was able to get the hair follicle done. I was able to leave during my lunch and go get it done and then go back to work. And I sent those results to the guardian ad litem. You
did send and do you have those now? I know it's been, gosh, probably about a month. So you do have those now?
Me or her? Sorry.
Oh, sorry, Ms. Call. Do you have the hair follicle results?
I do, yes.
Okay. So just right now, mental health assessment from respondent is still needed. And then petitioner, ma'am, you were supposed to do a psychiatric assessment. where are you at on that?
I have been trying to find the correct places to go in order to get that done. I was waiting on the place Heather had recommended and was calling just about every other day, and they finally had gotten back to me. I believe it was last week. So I gave Miss call on that and informed her what they had said to me. So I am now looking for another place to go to get that done.
I do certainly note that I've heard from other dockets and other family law cases that, getting in for mental health assessments and psychiatric assessments is really difficult right now. I get it. So I think the best thing to do on that front is to find, at least at this time on those two fronts, you folks are trying. You both did appear today, so that's all good news. I will sign an order extending the deadline for the GAL report because I think both of those items, well, all three of those items, I should say, are necessary for a complete report. How much time do you think, and I say this knowing what I just said, which is I'm very aware that it's really difficult for people to get in and be seen right now. So what's our timing, do you think? I guess, Ms. Call, I'll ask you.
As far as I understand it, Miss Emerson's information she gave me was that they told her it could be a month. I hate for the thing we're running into right now is we have a kiddo that's being restrained from seeing a parent. I have my own concerns and thoughts about that situation. But I do want to make sure that we're sensitive to that. The reason I'm requesting a psychiatric evaluation, I believe, is quite serious. And so I want to make sure we have that addressed. I know this puts us in a really, really tough spot. But I do believe Miss Emerson, she says she's trying to get in somewhere. Miss Emerson, have you been able to schedule it yet? Has anybody given you a date?
No, I have not been able to receive a date yet, but I am working on that. I'm actually currently looking for other places. I have someone else here with me, and they're helping me to look for other places around the area where I could get that done.
Well, what if we do, does 1 month feel too long? We still might not have an answer in 1 month, but I feel like staying in contact with the court is probably a good thing, depending on how this plays out.
Your Honor, would it be possible to address the other issue before we decide on this?
Absolutely. Let's do that. Okay. And my understanding from reading this, and again, please tell me if I'm wrong, and because there's minors involved, I'm just going to be pretty generic about identifying parties, but my understanding is the allegation is that the parent right now is not supervising, well, I'll just read it as stated, not properly supervising the victim and abuser, that they're not being kept separate at night. Sounds like they're often sharing sleeping space. So, Mr. Rooney, what would you like the court to know?
So I got my daughter, her week was over, and my daughter told me that when she goes to mom's, she's been staying at mom's friend's house the whole time. His name is Zach, is what she said. I said, well, do you have fun over there? She said, yeah, but mom drinks beer all the time. I said, well, how do you even know what beer is? Because my daughter's 6. And she said, well, because my mom drinks it all the time. I've seen her drink it like 100 times. And I was like, yeah. And I was like, so when you go to Zach's, where do you sleep? And she said, I sleep on the couch. I said, oh, is there an adult in there with you? She said, no, it's just me, my brother, and Zach's son. We sleep on the couch together. And then after I heard that, I filed the contempt for not supervised, and I'm recommending that we do professional supervision until she starts taking this serious, because I don't want this to happen again. And I recommend that professional supervision at her expense. I say at her expense because I don't feel like I should have to pay for it, because she won't take this serious and she's the one doing the contempt of court.
Ms. Emerson, how do you want to respond?
I just want to first point out that Mr. Rooney is not there, so he does not see anything that is actually going on. Therefore, I mean, my daughter, since all of this has began, I have completely flipped my entire life around. Every weekend that I have my daughter and she is home, I consistently have at least one other adult present at all times, just in case, for whatever reason, if I am making a meal for my children, then I'm not going to burn the house down, but I'm also still able to keep an eye on my kids. If I need to go to the bathroom, then hey, I can go to the bathroom and not be hyperventilating, freaking out, worried about what's going to happen. I have multiple people who have said that they will come into court, or they will even write a statement to tell you that I'm consistently watching my children. My kids do not sleep on the same couches. We have family movie nights, yes. Or you know what, we do sleep, we all sleep in the living room. Yes, I will not deny that because my children love family movie nights. But I always keep them on separate couches, separate recliners. There is always an adult present. And I am taking this very seriously. My entire life has been completely turned around because I want my daughter home where she has always been. I am consistently with her. If I am not, then there is a trusted adult, always, always, always. But they do not share sleeping spaces unless it is, family movie night, but it's opposite couches on opposite sides of the living room. And if you would like, even Your Honor, I do also have my mom joined in on Zoom as well, who can speak as to how my life has changed and how I am when my daughter is home and just how I am overall as a parent with both of my children.
Well, I'll be honest, I'm not quite as concerned about how your life has changed as why we are trying to create a scenario in which a young child has to spend any time anywhere near someone with these types of allegations. So I guess
Your Honor.
well, hold on. I'm very troubled by this. I mean, here's the deal. You're saying, sometimes they're in the room together because family movie night is very important to me. But I guess what's important to this court is that I know that I'm not forcing a child to be in a room with someone where these allegations of, I'm going to use the word allegations. I'd like to use a stronger word, but have been levied here. I guess that's where I'm having trouble here.
Your Honor, so CPS was involved. They came back with everything unfounded. I even sat there and I told the caseworker, hey, have you discussed it with this person or that person? I was in consistent contact with the caseworker. Everything came back as unfounded. The documents were even submitted to the courts. And if it is such a threat to my daughter to be near my son at any point in time, then why is it that my child is begging and pleading and crying, having a complete breakdown, throwing a fit, asking to call her father because she wants to stay longer?
Your Honor, when you're ready, I have some input for you as well.
Yes, please, Ms. Call. Thank you.
So I submitted an interim report, and beyond that report, in which I suggested that I was concerned that Ms. Emerson was not taking these allegations very seriously. It was after that report that I was able to interview our kiddo's mental health counselor, as well as the alleged abuser. The mental health counselor said something exactly similar to what Your Honor just said, which is that she was concerned. She 100% confirmed that the child is reporting that she has been abused and is still being abused, and does ask to see her abuser, because at this point, the child believes that this is a normal part of family life. Yep. And the counselor is very concerned that the child is spending any time with her abuser at all. When I interviewed the abuser, after 45 minutes of conversation, was able to tell me that they've been instructed not to talk to grownups about this situation, and that when they do, they get into trouble. Mm-hmm. I believe Ms. Emerson believes that she's doing what she needs to do as a parent to protect her child. But I believe that there needs to be more mental health support in this situation for all parties involved. And I believe that the child who's being hurt is still being exposed to an abuser who doesn't even know they're doing something wrong.
Hmm.
So I think there are very serious issues at play in this situation, particularly now that summer has come and the abuser isn't seeing the school counselor anymore. There are some immediate things I think that need to occur, including the abuser being in mental health treatment immediately. He is also a minor. This is a very difficult situation.
Your Honor, if I
Go
may.
ahead. Go ahead.
I just recently, as of yesterday, spoke with my daughter's counselor, and she recommended that we increase her counseling. So we were doing half hour once a week, and she feels that that's not enough time for them. So we did just increase it to an hour weekly every Monday as of yesterday.
So I appreciate that. Here's what I struggle with. I mean, I understand the contempt motion, but I'm much more inclined to say for me, this really is a safety issue for the child. I am going to propose that we, on an emergency temporary basis, restrict any physical contact between the minor child and the minor alleged abuser at this point. And in that order, Ms. Emerson, I mean, essentially what that means is the child, if the alleged abuser is at your house, then your daughter's not to be there, just period.
I understand that. We actually had already done that. The alleged abuser is actually in counseling. He is in the Community Health Integrated Services WISE program, which requires a minimum of 10 hours of participation a week. And we have been in that program since court started.
So is he residing at your house?
Yes. Currently, because it is summer, he is at my mother's for the time being. Just because, I mean, he's going to spend some time with family. But yes, he does live with me.
So if I were to issue an order where the two of them cannot be under the same roof, cannot be together, until we have more information from professionals and including your own assessments, are there ways to assure Mr. Rooney that when his daughter's with you, that the other person is not there? Because I'm kind of hearing two things from you, that the alleged abuser is with your mom, but that he also lives with you. And I'm getting the distinct impression based on the things I've read. And again, understandably, that you are in a position of kind of having to protect two children right now. So I'm not totally comfortable saying that I believe you would follow that order and not have the alleged abuser at home. So help me out here to feel more comfortable with this.
I do apologize, Your Honor, because my child does live with me. But because it is summer vacation, he is out on vacation out of town with my mother.
For how long?
Clarifies that. However, though, I have.
How long is he on vacation with your mother?
About 2 weeks, give or take.
Oh, so just a temporary thing. Okay.
Yes. But however, we did already do this before under Commissioner David Nelson's ruling, where my son wasn't to be there if my daughter was. And I complied fully with that. Then he dismissed that and allowed for my children to be together.
Yeah, I see that. I know. I'm looking at the March 30th order. And this is where there was allowed visitation, but that the female child was not to be alone with the male child. The male child was not to go into the female child's room. And that when they are together, there must be adult supervision. And
yes, ma'am.
Based on the allegations made to this point, I believe more likely than not that order's not being complied with. So
Your Honor, may I say something? I'm Adani's mother.
No, you may not right now. You're not a party to this case. Thank you. So I am very much inclined to amend the May 30, 2023 bench order. But I guess, Ms. Call, I would like some input from you. I know that you've been involved in this way longer than I have. And I'm certainly not asking you to make my ruling. I'm happy to sit with that, but what would be your proposal? And I'll tell you, I am leaning towards a solution where we can guarantee that the two children are not in a room alone together. And I'm not sure that I can guarantee that absent taking away visitation from the house.
I actually agree with you. In my interim report, one of the facts I cited is that the children's bedrooms at Miss Emerson's house are downstairs away from, they're on the bottom floor, and the rest of the living quarters are upstairs, including Miss Emerson's bedroom, and their bedrooms are right next door to each other. Miss Emerson did share that there was an alarm on her door, but I wasn't aware of that. I didn't witness that when I was there. I believe it's there. I'm just saying I didn't see it when I did my home visit. Mr. Rooney actually did file a temporary order of protection that was denied. So I would be in support of a recommendation that we try to protect this kiddo from being around her abuser at all costs. I have interviewed, to Miss Emerson's point, I have interviewed a friend who stated that he has been there in support of being in the room when the two children are together. However, I'm inclined to really pay attention to a mental health professional who says this child should not have to be exposed to the person who abused her and continues possibly to be abusing her while she's in treatment for being abused. It feels like a very conflicting situation that I think is deeply confusing for both children involved.
Yeah. I'm very uncomfortable with a child of this age essentially being forced because of a visitation schedule and a parent who isn't properly supervising, essentially to be forced to be with someone where there are statements in the record where this female child has said this did happen. And I have to take that at face value right now. So I am going to find a couple things. I'm going to find that Ms. Emerson, I do believe more likely than not, you are in contempt of the May 30, 2023 bench order. I don't find that there's been proper supervision to show me that compliance with the bench order has been made. In fact, your own testimony is that there are times when they are together because family movie nights are very important. And I would just say that kind of sits with me wrong. I think there's much more important things that you should be focusing on with this child than family movie nights. So I am going to find contempt. I'm not going to issue any money judgment because I don't find it's a violation of the true parenting or custody order. It's a violation of a bench order, which I think there is some difference there. So I wouldn't be comfortable charging $100, but I am going to write in there that I think that the remedy is that I have the authority and am going to revise on an emergency basis the March 30, 2023 bench order. At this time, until our next review date, I am ceasing any in-person visitation because I know that sounds harsh, but I cannot be convinced based on any statements made by Ms. Emerson today that there's a guarantee that the alleged abuser will not be in the house. So I'm ceasing in-person visitation. I will allow for electronic and video visitation to be coordinated through the My Family Wizard app.
Your Honor.
Go ahead.
So during my work hours, when she normally calls to talk with Myra, I'm at work and she has to call my grandma's phone. My grandma doesn't have a smartphone. She has a flip phone. So she doesn't have access to videos because I work from 6 to 6 Monday through Friday.
Yeah. Mr. Rooney, I think you're having a bandwidth issue. Can you turn off your camera? There you go. I heard the part about when she's with another party, there isn't video access. So just pick it up from there.
Yeah. So my grandma has a flip phone. She doesn't have the access. and I work a schedule Monday through Friday, 6 a.m. to 6 p.m. So I'm not able to use the app for the phone calls. So she's just been calling my grandma's phone directly. Is that okay to still continue to do that? I just won't be able to apply the video.
That's okay. I'm allowing electronic communication, and I'll clarify that it can be through My Family Wizard app, or so you're saying that that person doesn't have access to the app, right?
Yeah, my grandma doesn't have access. She has a flip phone, and I can, if the app is available on her tablet, if I can get it on her tablet, I would be able to do it then.
I see I see Ms. Call shaking her head, and it sounds like I think that's the direction we should go if you could set her up with the app. And I'll tell you my reasoning anyway, and it might mirror Ms. Call's reasoning, but in a case where I hear some indication that perhaps kids are being coached on what they should and shouldn't tell adults about this scenario, I do think it's important that we're able to monitor what is being said to kiddos.
Yes, and we're going to use the Wizard app because I actually agree with that because I haven't been able to figure out the Talking Parents app too well.
Okay.
Talking Parents actually doesn't allow for third-party observation either. I just learned that recently. So Our Family Wizard is a really nice way to have a third-party observation.
Yeah, so we'll do the My Family Wizard app then. So I think that's what I am going to fill out the contempt and create a bench order exactly along those lines. We'll get that filed and sent over to the parties today after docket. Let's set a review date so that hopefully we have all of the other items in place regarding a review of the GAL report. If we have mental health evals and those sorts of things. If we don't have those, obviously we can talk about further extending that deadline, and we can talk about any review issues that have come up with my new order restricting visitation. So I'm thinking of going to now July 26th or August 2nd.
Your Honor, I'd prefer August 2nd. I'm going to be out of town on July 26th.
Okay. Mr. Rooney and Ms. Emerson, how does August 2nd at 9 a.m. work?
That's fine.
Okay.
And I can make that work for me.
Okay.
In that motion I filed, Your Honor, I requested some additional GAL hours. This is a county pay case, so I wanted to request a few more hours for investigation before I continued on.
Yes, absolutely. I will approve that, and help me out. Is there a standard motion, or excuse me, order for that, or would Nelson just do that as a bench order?
I actually do not know the answer to that, Your Honor.
Let me ask around because I don't know either. So I'm going to make a note to myself. Hours extended. And I also need to sign an order that does approve the extension of the report. So I'll see if I can find something where I can do both of those things in my order, and I'll have that filed.
Thank you, Your Honor.
Was Ms. Myers present previously when I called this case? Yeah, I don't think I saw that. Okay, let me pull up my digital file here. What I'm showing, my notes are stating that we're here for pretrial management. So if the folks want to let me know what they are needing this court to do today, I do show that you have trial set for the week of July 17th. You have trial readiness July 11th. So technically we'd be doing pre-trial today. I don't have the other party present. So let me, I guess, first turn it over to you, Mr. Blacklaw. Are there issues that you believe the court needs to resolve before this goes to trial?
Yes. The phone calls have been completely unreliable. She's given us multiple numbers. She's had the abuser's number listed down. You can hear him in the background. She's having other people on the phone, she's busy talking. That's not the best for Hazel's sake. And she blew up over the phone when I was there one time, and she was cussing, just slandering my name, everything, while the phone is in Hazel's hand. So that is not okay in my perspective. And also, when I was away taking care of a charge back in 2017, she has threatened my significant other, that and Hazel resides with her, and she
Okay,
knows that.
Yeah. So, sir, let me just stop you there. It sounds to me, and I do note you were not present for the trial setting on May 31st, it sounds like.
Right.
So you missed that, but what you're bringing up to me right now sounds like factual issues to be resolved at trial. So I want to be very clear. Are you making a request of this court today, or are you simply asking that these issues be resolved at trial?
Today, I would like the phone calls to just stop until she.
Have you filed a motion? Have you sent me any evidence? I don't see anything.
There's a police report about that whole ordeal. She was scared for Hazel's sake and her own kids, and had to file a police report because
I don't think you're quite understanding where the status of this case is. You have a trial date set. We're here for pretrial. I can't tell based on what you're saying and the fact that the respondent isn't here, whether this truly is in fact ready for trial.
Right.
Ms. Turnbull, I'll turn it over to you. Maybe you can shed some light on this if possible.
I wasn't aware of the more recent allegations, but based on the history of the case, I have made recommendations in the past that the visitation be supervised, and Commissioner Nelson was reluctant to do that. Ms. Myers, I believe, has some mental health and potentially some drug addiction problems that she has been reluctant to seek help for. She's in a domestic violent relationship, and Hazel has been abused in her care. I don't know, it's been an extensive case. I don't know how much time you had to go through it and through my previous reports, but she does have a volatile personality, and I am concerned that what Mr. Blacklaw is reporting sounds like it could be very accurate. So without proof, obviously we can't say, but it is consistent with the nature of the case. And so, you know, like I said, in the past, I have recommended supervised visitations for mom. And I don't know whether mom's ready to go to trial, but she has not been always consistent about showing up for court. And I don't know that, so I'm not sure if we can, you know, were to delay it or continue it, whether she'd show up next time.
Yeah. So the temporary restraining order for physical interaction, is that still in place?
Yes.
Okay. So we've got that. So they're not seeing each other in person.
No.
That order did allow, that was back in January of 2023. That order did allow telephone visits 2 times per week.
Correct.
And so what you're saying, sir, is that you're wanting that to cease?
Yes. I don't see there being any positive outcome for Hazel's sake.
Well, here's what I'm going to say about that. I don't take away that that may very well be true. I don't think I have enough information in front of me to make that ruling right now, nor frankly was respondent served with any documents to give her the heads up that we would be addressing that issue today. So I think just under a due process standard, I think certainly, you know, she should be here, let's be honest, but where someone is on notice that their visitation rights might be taken away, they're probably more inclined to show up rather than what this is listed as today as pretrial management, which is a little bit different type of hearing. So my recommendation is she did participate in the trial setting and claims that she's ready for trial the week of July 17th. You folks both have a readiness on July 11th at 11:30 a.m. So I'm going to keep those. I'm going to keep those on the calendar.
Yeah.
If you believe on an emergency basis, there should be a new restraining order that amends the January restraining order and takes away the telephone visits. If you could file that quickly with the court, we could get you noted on a docket probably end of next week or first part of the week of July 10th before trial.
So exactly what am I going to the courts about?
If you're wanting this court to notify the respondent that we're going to have a hearing to modify the restraining order to take away telephone visits, I would need you to file a request to put it on our family law docket Wednesdays at 9 a.m. You would want to file a request for an amendment to the restraining order, or you can file a new restraining order. And then that does need to be served on her, so she would have notice that that's what we're addressing on that date. I think that's the only way through a due process standard I could really get to that issue. And again, I appreciate Ms. Turnbull's input, and I'm not taking away that what you're saying may very well be true. I think we just need to do it the right way. This request came as a surprise to me, which tells me, she probably would be surprised by this request too. So I think that's all I can do today.
Okay. So there's still phone calls twice a week, video phone.
Yeah, I think at this point, you're going to have to adhere to the orders currently in place. Do you have a way to, are those recorded conversations or?
They're not.
Say that again.
They are not.
They're not.
No.
So my only other recommendation, perhaps to kind of keep things in line, is that you could ask at the start of the phone call whether the other party agrees to be recorded. If they say no, obviously don't record it. If they say yes, though, then you can record it and use it.
Right.
So I think that's the best I can do for you today.
Okay. Is there any way to see if she's the recommendations and got the hair follicle test or any of the treatments that she's supposed to?
I'm not aware that she's done anything. She hasn't let me know.
Yeah, DV counseling was ordered. I'm showing mental health evaluation, hair follicle testing. When mother has completed those, she can revisit in-person visitation, telephone and video visitation to continue until then. So, I think that's kind of the status quo, because I don't have any newly filed evidence from you, sir, or from her. So I really can't make any changes today.
Okay.
You were not at trial setting. Are you prepared to go to trial July 17th?
Yeah.
Okay.
Is that the 11th or the 17th?
The 17th, the week of the 17th.
Okay.
So they'll
Your Honor, is that trial over Zoom, or do we need to appear in person?
Let me ask, are they doing those over Zoom? Informed me that on your readiness hearing, which is July 11th at 11:30, they can talk to you about in-person versus Zoom versus hybrid.
And that's at 11:30?
11:30 readiness. And that is by Zoom, correct? Yes.
Okay. And Your Honor, I would also like to request some additional hours, as this is a county paid case as well.
Yes. And I'll ask you the same question I asked the last individual. Do you know off the top of your head if there's a form Commissioner Nelson used for that, or did he simply do a bench order, or do you know?
I believe he did a bench order.
Okay. And I think I do see your motion and declaration back in May for the extension.
Yes. And so that covered my hours. I believe, I don't have it in front of me, but I believe that covered my hours up through the report. So this would be additional time for the trial, essentially. These hearings in the trial.
Okay. And the new, Rick, I guess probably review of the new evaluations and hair follicle results and.
Yes, assuming she does some.
Assuming, yeah. Okay. I will try to track down today what that order might look like and get it drafted and signed. Okay. And certainly, sir, again, if you need to renote to address the restraining order, you can do that. You would just need to make sure that she's served with whatever documents you're sending here.
Okay.
Okay.
That would be to the courthouse.
Yes. Yep.
Right.
All right.
Okay.
Thank you. Yeah,
thank you for your time, Your Honor, and thank you, Amy.
Mr. Farmer, are you able to hear the court? Yeah, thank you.
Yes, I am, Your Honor.
Okay. Because of where we're at in timing, I do want to get some information from you.
Yes.
So first, let me just ask you, have you all been able to go through mediation yet?
Yeah, that's what I was about to talk to you about.
Okay.
I don't know if I misunderstood, but I'm pretty sure Commissioner Nelson said that it's court ordered that somebody was going to contact us, but I didn't receive anybody, no contact from anybody about the whole mediation setup. So I went out of my way and I decided to schedule it.
Okay.
And we have mediation July 5th at 4 p.m.
Oh, okay. So what I'm going to do then, and apologies, if I would have known that, I would have called you a little sooner, because I think all we're going to do is just set a re-review date.
Oh, it's all right.
I do, because it was transferred to mediation, we do have to have that occur before I can even address any of the temporary orders being proposed. So in the meantime, follow whatever orders are currently in place. Go to mediation on July 5th, and then let's get you guys a return date. Ms. Hanson, any input from you?
No.
Okay. Well, thank you both for working together on getting a date set. I could set you for the following week, July 12th, or I could give you July 19th.
Either or works for me.
I'm free either.
Okay, let's put you on July 19th. I mean, this will change, but right now we only have one case set to July 19th. I mean, that will change, but maybe you won't end up on a 17 case docket again. So, so July 19th at 9 a.m. and we'll just indicate, we'll set this over for reviewing the outcome of mediation. And then we can address temporary orders that I know you folks have already filed with the court.
Okay, perfect. Thank you.
Yeah. Anything else?
Nope, that'd be all.
Okay. Thank you both. I see you there. Thank you. Do we have Jose Rangel Creed? I'm just going to double check our waiting room. I don't think I've seen this person log in at all.
Not surprised.
Have you seen him online?
No.
Okay. Have there been any hearings on this case yet?
No, ma'am.
Okay. And then Ms. Looney, I do see you present. Thank you for hanging in with us as well. I'm cutting into our other dockets. I know.
That's all right. I can't do them until we're done here.
Right. Ugh. And let's see. I do have your proposed orders. I believe, yes, I do have the proposed temporary child support order. I also have some temporary orders that Ms. Dale, you submitted to the court.
Yeah.
Is Mr. Rangel Creed somewhere where he cannot log in today? Do you have any idea?
Honestly, Your Honor, I have no clue his status regarding anything. As far as I know, he has no current residence, no legal job. I know he is pretty well known for working under the table, but no phone number. There's been no contact.
And I'm just going to make sure, has he been served with the temporary child support order?
We did send that out, Your Honor. I did have a note in my file that it had to be forwarded, I believe. I'm just double checking.
Yeah, absolutely.
I don't know. I don't have anything saying that it was forwarded or returned. And we did send that out on May 22nd.
Okay, just to his last known address, probably.
Yes.
I did, if it helps, I did make my own personal copies of those papers, I believe, that I received in the mail, and I put them in the packet that he got served at one of the local bars. He was spotted, and so he should have his own copies of those.
When you served him with the summons in this case?
Yes, ma'am.
Okay.
I knew that was going to be a problem with his current or his last current address. I know he was evicted from there, so.
Okay. So I'm just going to document my file that I am satisfied that he was aware of today's proceeding. On the note for motion docket that you filed, ma'am, you did put his address, but it also said current unknown. Was that in the packet you signed or you served on him?
Yeah, that's as far as I know, that's his last current or his last known address. His current address is unknown.
Okay, because you had the note for motion docket telling him to appear on June 28, 2023. Was that in the papers you had served on him?
Yeah.
And who served those?
It was actually my brother who had a run-in with him at the bar. And at first I didn't think he'd be able to, but after talking to Kurt Aganastu, he said that he would be able to serve him because he's not a direct member of this case.
And that's fine. I don't have any issue with whether or not that person could serve. I just want to make sure that, and I know, and I do see this, proof of personal service, gave the documents directly on June 10th. Oh, and you did list all of the things, which also included you specifically, so Wyatt Dale was the process server and specifically indicated court ordered child support state papers were in that packet.
Yes.
So I am going to find that respondent had actual personally served notice of today's hearing and all of the documents. So I think first, Ms. Looney, I'll hear from you on the child support order.
Thank you, Your Honor. So we took the information that we had available regarding his previous employment for Mr. Rangel Creed, and we used quarters 1 of 2023 as well as quarters 2, 3, and 4 of 2022 to come up with an average hourly wage of $31.25 per hour, which we imputed him at 35 hours per week. He has a history of only working part-time hours, but we have nothing indicating he's incapable of working a full-time work week. So we had a net monthly income for him for that of $4,017. We have imputed Ms. Dale as a TANF recipient at 32 hours a week at minimum wage with a net monthly income for her of $1,953. So we have a transfer payment that we are requesting of $705 from Mr. Rangel Creed to Ms. Dale, and we would ask that begin on July 1st.
And Ms. Dale, you've received and reviewed this order. Any objection to me signing this order as proposed?
No, ma'am, not that I can think of.
Okay. And I'm going to just indicate on this order in case it ever comes up that Mr. Rangel Creed not present, but court finds he was personally served.
Thank you for that.
Thank you, Your Honor.
And then I am also going to sign the worksheet. And Ms. Dale, you had also submitted temporary family law orders and parenting plans. You had submitted your own child support worksheet and child support order, but since we signed the state order, I'll at least take those out.
Okay, yeah, I did my best, honestly.
No, I understand.
Sure.
Without attorney representation, it is quite difficult. You are asking for a GAL to be assigned, is that correct?
I think
That would be like a guardian ad litem who kind of interviews you, tries to track him down to figure out what's in the best interest of the child for visitation and any limits on visitation.
I think I just put down the court, but if you think that's what's best, then we can do that.
Well, I thought you had, I mean, if he's not going to appear.
I don't think he is. Unfortunately, just being honest.
Yeah. Is there an indication? I'm seeing an indication of a current pending Longview criminal case involving a sex offense.
Yes, ma'am. But as far as I know, they can't go on with the investigation because they can't find him.
Okay. I think in this case, I just don't have enough information about what is going on, including criminal history. So what I'm going to do, I'm going to reserve on, and he doesn't have any visitation with kiddo right now, correct?
That is correct. There's none.
Okay. Okay. I think that your order is recommending no contact at all currently.
Yeah.
And he's not having any contact.
Yeah, the last point of contact that he had with Kaysen was the 4th of July last year.
Okay.
And since then I've taken notes. There's really been no calls and there's been, I mean, just no effort from his end at all.
The pending investigation, does it involve you as the victim in any way or the child as the victim in any way?
No, ma'am.
Okay. So I think what I'd be comfortable doing today, number one, I am going to appoint a guardian ad litem to get a little more background on whether there are factors that should permanently restrict the respondent. We'll go ahead and appoint Amy Turnbull. What I'm going to do, ma'am, is I'm not going to sign the restraining order at this time. I'm going to reserve on that pending further input from the GAL or other evidence. I think with your statement that neither you nor the child are victims of any domestic violence, I'm going to reserve on that. The parenting plan, I will sign as proposed, and essentially that gives you full custody. However, because I don't have enough information today to go off of, I'm going to reserve on the reasons for limitations. So you had checked essentially all the boxes, including abandonment, neglect, domestic violence, assault, sex offense. So I'm going to reserve to the full plan on those. And what that means is I'm not making a finding one way or the other. Okay. We're going to wait for more information before we make those findings.
Okay.
We are at this point, because of his non-appearance and the brief allegation of a pending sex offense, I will indicate that he's not to have contact right now. So essentially there will be no visitation, not even supervised. Certainly if he wants to change that, he can come to court. You will be the only parent making educational and healthcare decisions. I'm not going to find that there's a reason to limit his decision-making except for his non-appearance today. I am going to find that the history of his participation is what warrants restricting decision-making, not because of any neglect or abuse at this time. Again, reserving on that issue. I'm not going to have you guys go to mediation. You can stay in the court system. And again, with his lack of participation today, I doubt mediation would be useful at all.
Mm-hmm.
The minor child will live solely with you with no visitation scheduled at this time. Again, he isn't here, hasn't requested any, and it sounds like that's kind of a long-standing issue. We can readdress if and when he appears. So I'm not gonna list any transportation arrangements.
Okay.
I'm going to cross that out and just write no visitation ordered. I'm going to mark out your request for a no contact order at this time. Sign this order. Are the two of you unmarried?
Yeah, never been married.
Okay. So then I'll also fill out this temporary family law order. I think the amount you included here, $260, is that your filing fee?
Yeah.
Okay. I'm just going to change that right now and indicate no money judgment is ordered for that filing fee. And none of you are in the military?
No, ma'am.
Okay. The minor child, initials KC, approximately 23 months old?
Yes.
Okay.
Actually, he just turned 2 last week.
Okay, so I'm going to change that to 24 months. We're not assigning an investigator. It's just going to be a GAL. And you said your current income, when we were doing the worksheet, you received TANF benefits?
Yeah, I'm currently waiting to start an electrical apprenticeship.
Okay. So we'll revisit. I may reserve on your portion of appointing a GAL, but at this time, given your receipt of TANF benefits and his non-appearance, so we'll indicate that this will be county paid for now, but I will reserve on that if and when we get additional information, or if you do obtain employment while this case is pending, and if he appears, frankly. Any questions you have for me, ma'am, or anything else you need from the court today?
Yeah, what, if I could ask, what qualifies a parent as abandoning a child?
So I unfortunately can't give you legal advice. It is a statutory definition. So I can point you to, I guess, looking it up essentially, or talking to a lawyer, but there is a legal definition that we go by.
Well, that's what I kind of thought. It was like 3 months in Washington State. And then Kurt told me that he definitely qualifies as abandonment and neglecting, but I guess from what I'm picking up today, he doesn't.
If you recall, what I specifically said was I'm not making a ruling on that today. I'm going to wait for additional evidence. And in the order, it specifically says reserve ruling on things like abandonment, neglect, abuse.
Okay.
So those will be items for you to bring forward to this court. So the stage that you're in is you've requested temporary orders. That's what we've gone through today. Before your parenting plan is finalized, we will be going through the case to do final orders. Does that make sense?
Yeah. So is there like another hearing or something after this one?
Yep.
From
So
what I'm understanding?
Yep. We will set a review date for you with a new hearing date.
Okay.
Let's set a review for 30 days out. Well, yeah, let's put you to, are you available July 26th at 9 a.m.?
Yep, I can put it down and try my best to be there.
Okay. If something comes up and you cannot attend on that date, then please reach out to the court.
Okay.
Okay. Okay. Anything else you need from me?
Not that I can think of. I just wanted to thank you for your time and the state's time, so I can use my resources available to me now and kind of do my best for my son. And I appreciate you guys.
Yep. Yep. Best of luck. We'll see you back here in about a month. Okay.
Thank you so much. Have a good one.
You too.